This is not just another story about guns. This is a story about power, control, and the shocking truth that America doesn't want you to see. Every few months, another gun law falls struck down by the very courts that were supposed to enforce them. But why? Why are judges across the country rejecting restrictions that lawmakers fought so hard to pass? Is it freedom or something far more dangerous? Stay with me, because in the next few minutes, we're going to uncover the real reason why the courts keep dismantling gun control laws in America. And trust me, the final revelation will leave you absolutely speechless. Before we dive into this storm of controversy, make sure to hit that like button and subscribe to the channel. Your support tells YouTube that this kind of investigative content matters, and it helps more people see the truth that mainstream media refuses to talk about. Every like, every comment, and every subscription helps keep this channel alive against the tide of censorship and silence. So, if you believe people deserve to know what's really happening behind closed doors, take just 1 second to subscribe right now. Now, let's talk about the chaos unfolding in America's courts. One by one, state gun laws are being struck down. Assault weapon bans, magazine restrictions, red flag laws. Judges are tearing them apart using the Second Amendment as their shield. But here's the mystery. The interpretations keep changing depending on who sits on the bench. Some say it's about protecting constitutional rights. Others whisper that it's about political power, lobby money, and influence from behind the scenes. The lines between justice and ideology have never been this blurred. Are the courts defending liberty or rewriting the law to serve a hidden agenda? By the end of this video, you'll see why these decisions aren't just about guns, they're about the future of America's freedom itself. Watch closely, because the last revelation in this video will completely change how you see the legal system forever. And when you get there, tell me in the comments, which part shocked you the most? Let's uncover the truth together. 1. Historical foundations and the evolution of the Second Amendment. To understand why courts keep striking down gun laws, we must start at the beginning. The Second Amendment, though brief, has long been intensely contested. Early American legal tradition tied the right to arms to malicious service, but over time advocates for individual rights argued for broader protections. Decades of court decisions, scholarship, and public debate shaped what the amendment could mean. The watershed moment came when the Supreme Court formally recognized that the Second Amendment protects an individual right, not merely a collective militia-related right, and later extended that protection to state and local laws. But the court left a huge question unresolved. How far can governments regulate firearms without crossing a constitutional line? Over time, courts adopted tests like intermediate scrutiny or balancing tests, sometimes upholding restrictions if the government showed a strong interest in proven fit. Many gun laws survived under that framework. But now the balance is tipping. 2. The Bruen case and the history and tradition standard. Everything changed when the Supreme Court issued a ruling that replaced flexible balancing with a new test. A gun regulation must be justified by alignment with America's historical tradition of firearm regulation. Under this standard, first you ask whether the behavior falls within the plain text of the Second Amendment, and if so, whether the regulation is consistent with historical analogs from the founding era or shortly thereafter. If it fails that historical test, it must be struck down, no matter how compelling the modern public safety justification. This new method has forced judges into arguments over what counts as an appropriate historical analog, how narrowly to read past laws, and how much flexibility to allow. Because our world is filled with modern weapons, mass shootings, and urban density, conditions unimaginable in the 18th or 19th centuries, many modern regulations struggle to find a safe haven in history. As a result, courts are increasingly voiding gun laws that do not mirror or closely resemble older regulations. 3. Judicial philosophy, ideological tilt, and litigation strategy. Court decisions do not emerge in a vacuum. The judges who interpret the Second Amendment carry with them philosophies: originalism, textualism, skepticism of regulatory expansions, and deference to individual rights. Under the new historicist standard, those philosophies gain more power. Gun rights advocates and well-funded interest groups actively litigate to bring cases before friendly courts, shaping the judicial roster over decades to ensure favorable outcomes. Some states have even rewritten their constitutions to require stricter scrutiny or expanded gun protections. When courts view firearm regulation as a constitutional frontier rather than a policy domain, they tend to assert stronger scrutiny and less deference to legislatures. That activism, dressed in doctrine, increasingly tilts outcomes. 4. Key types of laws being struck down and legal reasoning. Let's examine some categories of gun laws now losing in court and the reasoning used. Purchase limits / one gun per month restrictions. In several states, laws limiting buyers to one firearm in 30 days have been invalidated because the courts ruled there is no sufficiently similar historic law authorizing that kind of limitation. Restrictions tied to domestic violence or protective orders. Prohibitions preventing people under restraining orders from possessing guns are now being scrutinized for lacking a historical analog, so courts sometimes conclude they cannot survive the new test. Sensitive place bans / gun-free zones. Certain laws barring firearms in places like public squares, transit hubs, or urban centers are challenged. Courts debate whether 19th century analogs, regulating swords in marketplaces, or prohibiting concealed arms in certain public spaces suffice to justify modern bans. Some bans survive, many do not. Assault weapon bans / weapon classifications. Bans on rifles with military features or high-capacity magazines are under fire. Because these weapons did not exist historically, courts demand analogous regulation of dangerous or unusual weapons, often rejecting the connection unless there's a close precedent. Age restrictions or classifications by category of person. Laws barring younger adults from carrying or limiting categories of persons from possessing firearms face difficulty if historical records lack similar classifications or age restrictions. In every case, the pattern is the same. Modern conditions and modern weapons often lack clear historical counterparts, and under the new standard that gap is fatal. 5. State-federal clashes and local resistance. Some states attempt to resist federal court trends. They amend state constitutions to elevate gun rights or impose strict scrutiny on any regulation. Others pass preemption laws to prevent cities or counties from enacting stricter gun control. Yet when those laws collide with federal constitutional doctrine, as defined by the Supreme Court, they too may be invalidated. Some states have seen their local government's regulatory efforts wiped out under federal court decisions. The result? A patchwork of legal landscapes, where similar laws are valid in one state and voided in another. Legislators increasingly hesitate to enact bold restrictions if courts are poised to strike them down. The legal battleground shifts from the state house to the courthouse. 6. Critiques, contradictions, and doctrinal tension. The new history and tradition approach has drawn fierce criticism. Some scholars argue it is practically unworkable. How can we fairly analogize from laws written before semi-automatic rifles existed? How far back does one look? Judges disagree wildly. The test may favor whichever judge is more permissive in interpreting historical equivalents. Many also criticize that the doctrine silences empirical evidence about violence, public health, and policy effectiveness because the standard is purely historical. Paradoxically, the court's earlier decisions acknowledge categories of presumptively lawful regulation, prohibition in schools, bans on possession by dangerous persons. But under the new regime, even some of those traditional exceptions are revisited or eroded. Another contradiction. Some jurisdictions had virtually no early firearm regulation recorded, so courts may simply say no precedent and void modern laws, even where modern problems are stark. That becomes a circular trap. You can't regulate unless there was regulation earlier. Earlier regulation wasn't present. The doctrine may privilege ideology over pragmatic safety and leave legislatures powerless. 7. Implications and what lies ahead. If courts continue this trajectory, the consequences are profound. Lawmakers may learn to cower. Any regulation, however reasonable, may invite swift invalidation. The locus of power shifts to federal appellate courts and the Supreme Court. Unelected judges become primary architects of gun policy. Policymaking becomes litigation strategy. States with stricter gun control may see regulatory collapse or legal chaos. Public safety arguments may be sidelined in favor of constitutional formalism. In the long run, the question is whether America allows judges to impose a rigid historical framework upon a modern society full of modern problems. And here is the final, chilling truth. When courts begin nullifying laws passed by legislatures in the name of history, democracy itself is imperiled. The last revelation. We are entering an era in which the judiciary, not elected bodies, may become the true designer of America's future, forcing us to conform to centuries-old norms even as society evolves. Thank you for staying until the end. If that final idea shook you, if any point stunned you, please like, subscribe, and share. Your engagement keeps this channel alive and ensures these difficult truths reach more people. And tell me in the comments, which topic surprised you most? Bruin's test, assault weapon bans, judicial power, or something else? Your voice shapes this conversation.